So, hello everyone. It's good to see you all again. So, morning we started this session at 10 a.m. and it is being successfully going on for the past 8 hours. So, we have successfully completed the 8 hours of continuous discussion. So, only 4 hours to go. So, from 6 to 10. From 6 to 7, me, Adil Baig, I will be discussing about the landmark amendments of the Constitution. From 7 o'clock, Mrs. Madhavi Madam, senior faculty of KingMakers, she will be discussing about the institutions in the Constitution. Next at 8 o'clock, we are having a special session that is aspirants' view of India's Constitution. So students of KingMakers IAS Academy will share their views. And at 9 p.m., we are having our CMD, Mr. M. Bhuminathan, who will be joining us and he will be discussing about why we need to celebrate the Constitution. And the session will be over by 10 p.m. So this is the agenda for the rest of the 4 hours. So now we'll start our session of landmark amendments to the India's Constitution. So morning already I was discussing mainly about one important feature, that is Constitution. Our Constitution of India is having a right blend of both flexibility and rigidity. So this was the topic which was going on in the morning. So while we are discussing, we were discussing a lot of features about when we were discussing all these features. I also discussed about this one particular feature in specific. So amendments of the Constitution itself and amending power and the nature of amending power itself is a very important reason why our Constitution is one of the most successful Constitution. Because if we so Constitution is nothing but a book. It is just that book. This book is providing the basic essence of the governance. It is providing the political administrative structure of the nation. It is identifying the rights of the citizens. It is identifying the duties of the citizen. It is identifying the duties of the government. It is listing the provisions of power of state government, union government, and all the levels of the government. And mainly, it also enshrines the ideals which this Constitution which is going to follow. So all these things are mentioned by the Constitution. So it is a book. So based on book, we are running our nation. So, but this book was written in 1949. So 1949 means it is almost 73 years ago. So none of the ideals and none of the values or none of the culture is always constant. Change is inevitable. மாற்றம் ஒன்றே மாறாதது. So மாற்றம் வந்துகிட்டே தான் இருக்கும். So when time moves, when time progresses, automatically there is also a necessity for the changes in the values. So changes in the system, changes in the structure, changes in the technology. So there is a lot of changes in technology which is coming. There is a lot of advancement in the economy we are seeing. So with all these changes, our Constitution also should change, because it should not be rigid. If it is rigid, it will be fossilized in history. So it will be fossilized in history. So any book, be it which we are practicing for the life, it should not be rigid. It should be flexible to adopt with time. Adopting with time is very important for anything to succeed. If anything is not adopting with time, it won't succeed. It will be irrelevant, and it will be backward. It will be regressive. So anything, any ideals, any concept should adopt with time. So that adaptability with time is enshrined by our Constitution by Article 368. This 368 article of the Constitution is very important article, which enhanced the longevity of the Constitution. Because whenever there is a problem, whenever there is a need for a change, we are having three set of principles to adopt it. Like for example, in Article 368, we are having three amending powers. That is, a few amendments can be done by simple majority of the members present and voting. Like what kind of these amendments? Like amendments like changing the name of the states, languages, number of judges in the Supreme Court. இந்த மாதிரி குட்டி குட்டி விஷயங்கள் எல்லாம் easily we can amend. So அதுக்கு ஒரு difficult procedure இல்லை. But there are certain provisions which can be changed only with the special majority, like fundamental rights, DPSP, or any other provision which is not there in the provision 1 and 3. So these provisions can be amended only when the 2/3 of members present and voting are approving, and majority of the total membership of the house. Both the conditions should satisfy. 50% மேல people vote பண்ணிருக்கணும். 2/3 of the member also should be present, should be approving it. So This is special majority. And there is third provisions. There are certain provisions of the constitution which is relating to federation. So India's federation and federal features, like schedule 7, like we are having powers of high court, powers of legislature, and powers of judiciary, high court, and there are many other provisions with respect to taxation and center state relation which can be changed only with the ratification. So not only by special majority, after special majority in Lok Sabha and Rajya Sabha, it should also be approved by 50% of the states. So this is one important feature of the constitution. So in the Mari, a blend of rigidity and flexibility had made sure that our constitution is surviving for so long. So that has made our constitution a most successful constitution. If you ask what is the secret of this our constitution, it is the amending powers. So that is the one main thing. These amending powers sometimes gave unbridled powers to the parliament. So we saw, like for example, there was many amendments between 25th Amendment to 42nd Amendment, where the Parliament got unbridled power and it started amending a lot of things in the Constitution in a much controversial way. And we had the president rule, we had the emergency and all these things, which created a huge controversy. At the same time, this amendments made was again corrected in 44th Amendment. So that is the beauty of our constitution. So it was corrected in the 44th Amendment, and when Parliament was exceeding its amending power, at the right time, we had a beautiful judgment in Kesavananda Bharati case in 1973, where 13 members judges, 13-member bench of Supreme Court said that amending power of the Parliament under Article 368 is restricted. Parliament can amend any provisions of the Constitution, and it should not accept the basic structure of the Constitution. So this basic structure doctrine, which is acting as a limitation to the amendment power, itself is a beautiful judgment which enhanced the longevity of the Constitution for another 50 years. That is what we are discussing today morning. So next year is going to be 50th year of Kesavananda Bharati case. So that is a very crucial landmark moment in the Constitution, which also restricted the power. So our Constitution is having so many checks and balance and safeguards, which ensures that it is being surviving. So that is the secret of our Constitution. So now in this session, we will discuss crucial amendments in the India's Constitution. So India's Constitution had at present 105 amendments. So in the past 72 years, we are having 105 amendments. So in this 105 amendments, various parts of the constitutions underwent changes. Like for example, there were many frivolous amendments and there were many serious amendments too. Previous amendments means like 32 amendments of the constitution deals only with the reorganization of territory, acquisition of territory, creating new states, all these things. So acquisition, so these kind of territory and state-based provisions are amounting to 32 amendments, not 32nd amendment. 32 number of amendments are related to adjustment of territories. And another 12 amendments is the procedural thing, that is the extension of reservation given to SC, ST and Anglo-Indians. It was extended. So initially the reservation in the Legislative Assembly and Parliament was only restricted to 10 years of the Constitution, but it is being extended every 10 years. So this reservation provision in the Legislative Assembly and the Parliament for the SC, ST and Anglo-Indian is being extended every 10 years. So this extension amounted to 12 times. So this is another important thing. So in the Mari reservation related extensions on the procedural thing, which is not significant. So in the Maria almost 44 amendments has gone. So rest of the 60 odd amendments, there are many crucial amendments, landmark amendments, like the first amendment itself and 42nd amendment, 44th amendment, and we are having 86th amendment which brought the right to education. So we are having 101st constitutional amendment which brought the GST. So all these amendments are considered to be the landmark in the constitution. So that is what we are going to discuss today, landmark amendments in the Constitution. So it is always good for our preparation also, UPSC preparation also, to remember these landmark amendments. So of all the amendments, the most crucial amendment of our Constitution is the First Amendment. The First Amendment of the Constitution was brought in 1951 itself. So this First Amendment of the Constitution was brought by Nehru government, and it brought in many crucial features. A few was very important. That is, to implement the land reform. So when we got independence, one of our aim is to ensure the distributive justice and welfare. So we brought this land reform. So when we were bringing in this land reforms, we had government abolished the zamindari system, and it brought the land ceiling acts, and it confiscated the land. But land right to property is considered to be the fundamental right at that point of time. Since it was considered fundamental right, a lot of writ petitions were filed in the first year of the constitution's existence itself to protect their land from the ceiling of the government. So the first amendment to the constitution was brought, which provided ninth schedule of the constitution. So initially the constitution had only eight schedules. So ninth schedule of the constitution was added in the first amendment, which said that any act placed in this particular ninth schedule will be exempted from judicial review. So what does it mean? So the acts which are related to land reforms, the acts and procedures and the schedules which are related to land reforms were added into this particular ninth schedule, which exempted the so judicial review, which were exempted. Of course, yeah, in a Coelho case, Supreme Court said that none of the articles can be safe from the judicial review in 2007, and all the acts placed in the ninth schedule will be reviewed by the Supreme Court whenever needed. So even though it was nullified in the Coelho case, but in 1951, it was a very crucial moment where ninth schedule was introduced and acts related to land reforms were kept out of the judicial review. The second important provision is reservation. So Article 341 was amended, and it empowered the state to make special provisions for the advancement of socially and economically backward classes. So there was some alteration in DPSP and in 341 of the Constitution, which enabled the provisions to provide reservations to the people belonging to socially and educationally backward classes. So socially educationally backward classes people were provided education, were provided reservations only based on the amendments which were brought in the first amendment. So that's why first amendment is historic, because that laid the path for the reservations in the government employment, and that laid the path for the reservations in the constitution. So that is one crucial amendment. The next important thing is, of course, that is the controversial thing which was brought by the Nehru. At that point of time, one particular press of Madras, it wrote a controversial article regarding the government's functioning and the constitution itself. So that article was it was writing against the constitution. So at that point of time, that person was arrested and that publication was stopped. So it was considered to be breaching the press freedom. So that created a huge furor, and at that point only we realized that Article 19, freedom of expression, cannot be without any restriction. So when we are giving freedom of expression, there should be reasonable restrictions. So that's why reasonable restrictions were added, like public order, friendly relations with foreign states, and incitement to an offense. If you are inciting an offense, friendly relations with foreign state, and public order, these three words were added in Article 19 to restrict the freedom of expression in First Amendment only. After that, Thapar case. So Thapar case of 1951. Okay. So these are all the crucial amendments which were brought, adding the ninth schedule and providing the reservation, enabling the reservation, and to implement the land reforms and reasonable restriction in speech. Like just now we saw, right of one person is restricted when it is affecting the right of another person, and if it is creating the public order disturbances. So First Amendment is a crucial amendment of all, which provided the three important provisions of reservation, ninth schedule, land reforms, and reasonable restriction on the right to freedom of expression. So after this First Amendment, we had many other amendments, but they were not landmark ones. So what we are going to discuss in this session is landmark amendments, which propelled the course of the Constitution, that led to the evolution of Constitution, that enriched the Constitution, or that affected the course of the constitutional journey. So these kind of landmark amendments only we are going to discuss. So adala most important amendment which everyone should know is First Amendment itself, which was brought in 1951. So next important amendment. So after that, we Article 31A, 31B. So Fourth Amendment, we add this 31A, and 31B and C was brought in, and then there was certain amendments to extend the union list provisions. So all these things was there. Next crucial amendment is Seventh Amendment. Seventh Amendment of Constitution is considered to be a landmark amendment because it was about the reorganization of states. So when the constitution was brought, we classified the states into Part A, Part B, Part C, Part D. So we classified the states into 4. In Part A, it had the British India provinces. Part B and C. Part B had the provinces of princely states. Part C had the chief commissioners provinces, and Part D is about the Andaman and Nicobar. So this distinction among the states was removed, and states were reorganized based on 4 principles as recommended by the most important committee. So JVP committee. So I'm sorry, not JVP committee, Fasal Ali committee. So this committee recommended 4 important reasons under which these states can be created. That is for administrative and administrative convenience, and linguistic and cultural homogeneity, for providing the economic benefits. So these are all the conditions for providing economic benefit and implementation of schemes and policies, and for the integration of the nation, unity and integrity of the nation. So these were all the conditions based on which the new states can be created. So this provision was added in the 7th as per the Fasal Ali committee. So after the Fasal Ali committee's recommendation in 1953, we had the protest of Potti Sri Ramalu, who demanded for separate state of Andhra Pradesh. So all these things led to reorganization or state reorganizations in 7th Amendment, along with the State Reorganizations Act, where we removed the Part A, Part B, Part C, Part D classification, and we brought 14 states and 6 union territories. At present, we are having 28 states and 8 union territories. At that point of time, we had only 14 states and 6 union territories. And it extended the jurisdiction of one high court to cover many states. That is one important thing. Then high court of a state can have jurisdiction on the adjacent union territory, and one common high court for more than one states, like Punjab and Haryana having common high court. In the mari vandu many provisions were brought in, and provided the appointment of additional and ad hoc judges. Article 224 and 223 and 224, appointing the additional and ad hoc judges, acting judges for the high court, and the provision also was added. Suddenly when new states were created, the high court demanded a lot of work burden. So on the work burden la adhigamanadanaala they brought in a additional and acting judges provisions for high court. So 14 states were created, and over the period of time. And why this 7th Amendment is landmark? Because it opened up a space for creating linguistic states. So I already said in the morning, creation of linguistic state is a landmark moment, because if the government, because linguistic allegiance to linguism is higher than any other sentimental allegiance. So person alliances with the linguism is very strong. If the linguistic self-determination is not provided to a particular population, then that will lead to unrest, as we saw in Bangladesh, where the Bengali language versus Urdu language created a new country called Bangladesh. Like we saw in Sri Lanka, where Sinhali and Tamil clash was there, that led to a civil war, brutal civil war. So linguistic identity is a very important identity. So creation of linguistic states led to the self-determination of the linguistic groups. So this also opened up for creation. Like at 1956, we had only a few linguistic states, and then we created Gujarat, and then we created Punjab. So these kind of linguistic states followed the course of action over the period of time. So that is why so creation of linguistic state further strengthen the unity of India as against the belief of the JVP committee. JVP committee said that no need to create a linguistic state because it might affect the unity of India. But creation of linguistic states only has strengthened the unity of India, because all the linguistic groups got the self-determination. Now we are having Gorkha land issue. Gorkha land, the group of people in Gorkha land region of West Bengal, they are demanding the separate state because of Bengali imposition on the Gorkha people who are having Nepali as their mother tongue. So this Gorkha land issue is going on in West Bengal. So linguistic demands are higher. And we all know language issue is a very sentimental issue in India. So that is the main landmark amendment is 7th Amendment. So after 1 and 7, the next crucial amendment to the Constitution is 15th Constitutional Amendment. So because in between all the amendments between 7th and 15th are all related to territorial reorganization and creation of new states and all these things. Like 11th Amendment would have altered the procedure for appointment of Vice President. Vice President appointment with the 11th Amendment. So I request all the aspirants to note down. அதாவது நீங்க வந்து இந்த நம்பரை மட்டும் நோட் பண்ணிக்கோங்க. 1 நெக்ஸ்ட் வந்து 7, அப்புறமா நீங்க என்ன பண்ணுங்க, அந்த நம்பருக்கான அமெண்ட்மெண்ட் போய் டீடைல்டா படிங்க. ஸோ நம்பர் 1 இஸ் தி க்ரூஷியல் அமெண்ட்மெண்ட், நெக்ஸ்ட் நம்பர் 7 தான். நம்பர் 7க்கு அப்புறமா நம்பர் 15. ஸோ இந்த மாதிரி நம்பர் மட்டும் நோட் பண்ணிக்கிட்டு அப்புறம் லக்ஷ்மிகாந்தோ இல்லை எனி அதர் சோர்ஸோ எடுத்து யூ ஜஸ்ட் ஸ்டடி. ஓகே. So next is 15th amendment. 15th amendment is a crucial amendment because it provided the power to High Court to issue writs to any person beyond the territorial jurisdiction of the state. ஸ்டேட்டுக்கு வெளியில இருக்கிற ஒரு பர்சன் கூட they can impose the writ. So in the statement was also a question in the preliminary. So அதனால that is very important thing. It increased the retirement age of the High Court judges from 60 to 62, and also it provided for the appointment of retired judges. ஸோ இதுக்கு முன்னாடி 7th amendmentல ஆக்டிங் ஜட்ஜஸ்க்காக பார்த்தோம். ரிட்டையர்டு ஜட்ஜஸ் டெம்பரரியா they can be appointed as high court judges. So that provision also was added in the 15th amendment. ஏன்னா like it altered the high court judges power. So இந்த மாதிரி ஒரு சில amendments were brought in the 15. So after 17 it is 15 is the considered to be a very crucial amendment to the constitution. So next important amendment after 15th amendment is considered. So after the 15th amendment, a lot of amendments were brought in, which dealt with a lot of trivial provisions, not very crucial ones. Like 21st amendment added Sindhi as a official language, because in the 8th schedule we had only 14 languages, and Sindhi was added as a 15th language in 21st amendment. About languages I will talk separately at the end. So after 15, the next crucial amendment is 24th and 25th amendment. So 24th and 25th amendment are considered to be crucial. So why they are considered to be crucial? Because that 24th and 25th amendment only led to the famous Kesavananda Bharati case, about which we are talking over the period of time. So the Kesavananda Bharati case, which was adjudicated in 1973, was a retaliation to the 24th and 25th amendment of the Constitution. So that's why it is crucial. So 24th amendment, what it brought? So 24th amendment said that Parliament can amend any part of the Constitution. So Parliament can amend any part of the Constitution. It gave unbridled power to the Parliament to amend any part. So அதனால Parliament started amending many crucial provisions, and it created a lot of controversy. So Parliament started amending a lot of many provisions. Like for example, it increased the like Parliament like President powers, President's advice of the Council of Ministers is binding on President. இந்த மாதிரி controversial provisions எல்லாம் பண்ண ஆரம்பிச்சிட்டாங்க. So like for example, the same 24th amendment gave a power that it made it compulsory for the president to give an assent to the constitutional amendment bill. So till 24th amendment, president can even deny the acceptance for the constitutional amendment bill. Ana after the 25th amendment 24th amendment, when a constitutional amendment bill is given to the president has to give assent by default. So this provision was added in 24th amendment. So that's why it is crucial. So from then onwards only, all the constitutional amendment bill, whenever it goes to president, by default the consent is given. But if you could see in 24th amendment, the first provision is the triggering point for Kesavananda Bharati. Parliament can amend any part of the Constitution, including fundamental rights. So that is also one about like Bharat sir was talking. Bharat sir was talking about the controversy between the fundamental rights and DPSP. So this is the one trigger, that is 24th amendment. Next, 25th amendment. So what were all the provisions the 25th amendment was doing? 25th amendment also came in the same year. It curtailed the fundamental right to property. Fundamental right to property can be curtailed அப்படிங்கிற ஒரு provision இருக்கு. And it provided that any law which is brought by the parliament to give effect to article 39B and C. So 39B and C of DPSP, what it discusses? It discusses about distribution of wealth and prevention of concentration of wealth. So it talks about the distributive justice. So in the distributive justice பத்தி பேசுற article 39B and 39C இதை implement பண்றதுக்கு if Parliament is bringing in a law, that law cannot be called as violating Article 14, 19, and 31 of the Constitution. So fundamental rights. So fundamental rights are 14 about equality, 19 about the right to property, and 31 there is some right to property. 19 right to property irukku, right to acquire. 31 right to property irukku. So Article 39B and C implement பண்ணும்போது, if it is contravening the 14, 19, and 31, it cannot be scrapped. அப்படிங்கிற ஒரு provision 25th amendment government is bringing. And 25th amendment most crucial controversial thing என்னதுன்னா, Parliament when it is bringing in a law to implement the to curtail the fundamental like to giving effect to the this thing, Article 39B and C, there is no judicial review. Judicial review கிடையாது அப்படிங்கிறது சொல்லிட்டாங்க. See, first என்ன சொல்றாங்க, 39B and C implement பண்றதுக்காக, if it is violating 14, 19, and 31, then government can bring in அப்படின்றாங்க. அப்படி கொண்டு வரலாம், it is out of judicial reviewன்றாங்க. So this is another trigger. Out of judicial reviewன்னு சொன்னது it's another trigger. So இது எல்லாமே நடந்த போது கேசவானந்த பாரதி அப்படிங்கிற ஒரு religious denomination உடைய land was taken by the government. So அதனால he filed a case and that became a constitutional case. And கோலக்நாத் கேஸையும் ஓவர்கம் பண்ணணுங்கிறதுனால 13 judges was brought in. ஸோ அந்த 13 ஜட்ஜஸ் கேஸோடைய ஜட்மெண்ட்ல 7-6 அப்படிங்கிற இதுல வந்து they provided a historic judgment which said that 24th amendmentல there is one thing, parliament can amend any part of the constitution. அது unconstitutional அப்படின்ட்டாங்க. எனி பார்ட்லாம் கிடையாதுப்பா, parliament can amend any part, ஆனா you cannot amend the basic structure அப்படின்னு சொல்லிடுறாங்க. You cannot amend the basic structure of the constitution. So basic structure doctrine was born on April 24th 1973 as a reply to 24th amendment and 25th amendment. நெக்ஸ்ட் வந்து பிரசிடென்ட் வந்து கான்ஸ்டியூஷன் அமெண்ட்மெண்ட் பில் போனா கண்டிப்பா ஒத்துக்கணும்னா ஆமா அது ஒத்துக்கலாம் அப்படிங்கறது அதை வந்து எதுவுமே டச் பண்ணல. அண்ட் தென் இட் கர்டைல்டு, அதே மாதிரி வந்து இட் ஆல்சோ அப்ஹெல்டு த Article 39 B and C in order to ensure the redistributive justice if Parliament is bringing in a law, if that law is contravening the Article 14, 19 and 31 of the fundamental rights, then that law is valid. So நீங்க Article 14, Article 19 and Article 31 can be curtailed to implement Article 39 B and C. So B and C பண்றதுக்காக you can violate even the fundamental rights. So இந்த ரெண்டு DPSP மட்டும் they are above fundamental rights அப்படிங்கிற மாதிரி ஒரு situation வந்து கேசவானந்த பாரதி கேஸ்ல they are upholding. ஸோ இப்படி அப்ஹோல்டிங் பண்ண உடனே என்ன ஆயிடுச்சு, ஸோ கேசவானந்த பாரதி கேஸ் கேம் அண்ட் இட்ஸ் 50 years now. இப்படி வந்து என்ன பண்ணிட்டாங்க, சுப்ரீம் கோர்ட்டே வந்து 39 BNC இம்ப்ளிமெண்ட் பண்றதுக்காக ஃபண்டமெண்டல் ரைட்ஸை கர்டைல் பண்ணலாம் அப்படிங்கிற ஒரு ப்ரொவிஷன் கொடுத்த உடனே நம்ம பார்லிமெண்ட்டுக்கு ஜாலி ஆயிடுச்சு. ஸோ இந்திரா காந்தி என்ன பண்ணாங்க, வாவ் அப்படியா, நான் அப்போ என்ன டிபிஎஸ்பி இம்ப்ளிமெண்ட் பண்ணாலும் இனிமேல் நீ கேட்கக்கூடாது அப்படின்னு வந்து என்ன பண்றாங்க, 42nd அமெண்ட்மெண்ட்ல ஒரு ப்ரொவிஷனை கொண்டு வராங்க. அண்ட் தட் லெட் டு another tussle in the Minerva Mills case. So 24th and 25th amendment are very crucial. We'll discuss about the continuity of this particular issue in the 42nd amendment also. Okay. So இதுதான் வந்து 24 and 25 they are very crucial part. So அதே வந்து நம்ம வந்து நோட் பண்ணிக்கணும். So 24, 25. So after 24 and 25, next crucial amendment to the constitution is 33rd amendment. அதுக்கு நடுவுல வந்து நிறைய சின்ன a lot of small amendments were made which is regarding the territory and which is regarding the Lok Sabha seats. In case 31st amendment of the constitution இருக்குல்ல, till 31st amendment of the constitution of 1972 we had only 525 seats in Lok Sabha. It was increased to present number of 545 in 31st amendment. 31st amendment it was made into present number of 545. So next important amendment is 33rd amendment. 33rd amendment is a crucial amendment because it brought in a provision that if at all an MP is resigning from the post, if or MP if they are resigning from the post, they have to provide the resignation letter to the speaker and chairman. So the speaker and chairman கிட்ட resignation கொடுத்தாலே அவங்க வந்து resign பண்ணிடலாம் அப்படிங்கிறதா இருந்தது. But 33rd amendmentலாம் it brought என்னதுன்னா, only if the speaker is satisfied, only if the chairman is satisfied that resignation is genuine, then only they can be resigned. இப்போ just like that ஒரு MP வந்து they are writing resignation letter, our resignation letter எழுதி கொடுத்துட்டதுனாலே வந்து that doesn't mean that they can be they are no more MP. Resignation letter வந்து speaker or chairman accept பண்ணாதான் they are considered to be resigned. அப்படிங்கிற provision was brought in 33rd. So why I am telling this provision is crucial, ஏன் அதை நான் சொல்றேன்னா, many MPs will be forced by their political parties or their political bosses to resign. அப்படி ஃபோர்ஸ் பண்ணி வேற வழி இல்லாம தான் ரிசைன் பண்றாங்க அப்படிங்கிறது ஸ்பீக்கருக்கோ இல்ல சேர்மனுக்கோ தெரிஞ்சதுன்னா அவங்க என்ன பண்ணலாம், ஓகே ஸோ தே ஆர் பீங் ஃபோர்ஸ்ட் டு டூ தி ரெசிக்னேஷன், ஸோ திஸ் இஸ் நாட் ஜென்யூன் அப்படிங்கிறத வச்சு பண்ணலாம். ஸோ இதனால என்ன ஆகுது, இட் இஸ் இன்க்ரீசிங் தி பவர் ஆஃப் தி எம்பி. ஸோ இது வந்து டிக்ரீசிங் தி பவர் ஆஃப் தி எம்பி இல்ல, power of the MP and rights of the MP, and it is providing some rights to the MP, member of parliament. Like Bhaskar Krishnamurthy sir சொன்னார், member of parliaments are crucial. அவங்க வந்து சர்வன்ட் கிடையாது, they are representatives. அந்த representatives உடைய பவரை வந்து it is extending. Okay, so that's why 33rd amendment is considered to be crucial, which ensured that satisfaction of the chairman. Like in our example சொல்றேன் பாருங்க, ஸோ எக்ஸாம்பிள் குள்ள போனா நிறைய கதை வரும். ஸோ 33rd amendment மட்டும் ஞாபகம் வச்சுக்கணும். நிறைய ரெசிக்னேஷன்ஸ் வந்து ஸ்பீக்கர் அக்செப்ட் பண்ணல. லைக் ரீசெண்டா நீங்க பார்த்திருப்பீங்க, ஆன்டி டிஃபெக்ஷன் லா கேஸா இருக்கட்டும், ஆர் many president rule cases were going on in a lot of states like Madhya Pradesh resignation accept பண்ணல. You know the controversy. அதனால தான். So that is 33rd amendment. So after 33rd amendment, another crucial amendment is of course, which is also called as 42nd amendment. எனக்கு இன்னொரு பேர் இருக்கு, பாஷா அப்படி மாதிரி. So then came the 42nd amendment. அதுக்கு இன்னொரு பேர் தான் என்னது mini constitution. So 42nd amendment is also called as mini constitution because it brought in a lot of provision. ஏகப்பட்ட ப்ரொவிஷன் வந்து கான்ஸ்டியூஷன்ல வந்து அது கொண்டு வந்துச்சு. அதனாலே இட் இஸ் கன்சிடர்ட் டு பி அ மினி கான்ஸ்டியூஷன். ஏகப்பட்ட சேஞ்சஸ். ஸோ யூ சா இப்போ நம்ம வந்து அங்கேருந்து கண்டினியூ பண்ணலாம். என்ன ஒரு கண்டினியூட்டினா லைக் இன் 25th அமெண்ட்மெண்ட் கேசவானந்த பாரதியில் சுப்ரீம் கோர்ட் என்ன சொல்றாங்க, யூ கேன் amend the fundamental rights in order to ensure 39 BNC. So 39 பிஎன்சியை இம்ப்ளிமெண்ட் பண்றதுக்காக நீங்க வந்து அமெண்ட் பண்ணலாம் அப்படின்னு சொன்ன உடனே பார்லிமெண்ட் குஷி ஆகி என்ன பண்றாங்க, அப்படியா இனிமேல் நான் எந்த டிபிஎஸ்பி இம்ப்ளிமெண்ட் பண்ணாலும் I can violate the fundamental rights. 39 BNC இல்ல, if parliament is implementing a law to ensure DPSP, even if it violates any fundamental rights, then that should not be called on for judicial review or strike down அப்படிங்கிற மாதிரி அதை எக்ஸ்டெண்ட் பண்ணிக்கிறாங்க. ஸோ இதுதான் வந்து 42nd அமெண்ட்மெண்ட்ல வந்து கொண்டு வந்த முதல் ப்ரொவிஷன். இதான் வந்து மினர்வா மில்ஸ் கேஸ்ல சுப்ரீம் கோர்ட், ஐ கேவ் யூ பவர் ஒன்லி டு இம்ப்ளிமெண்ட் 39 பிஎன்சி. ஒரு சின்ன பவர் கொடுத்தா நீ என்னென்ன பண்றேன்னு சொல்லி தான் மினர்வா மில்ஸ் கேஸ்ல அதெல்லாம் கிடையாது, 39 பிஎன்சி. அண்ட் அப்போதான் என்ன சொல்றாங்க, மினர்வா மில்ஸ் கேஸ்ல தான் they are telling that the balance between the fundamental rights and DPSB, the harmony and balance between the fundamental right and DPSB is a basic structure of the constitution அப்படின்னு மினர்வா மில் கேஸ்ல they upheld. So that's why இது நம்ம விஜய் காமெடியில வர மாதிரி தான், வடிவேல் வந்து அவரோட ஊர்க்காரர்னு சாப்பிட கூப்பிடுவார் பகவதி படத்துல. 2 பேர்னு சொன்னேன், ஒரு கிராமமே சாப்பிட்டுக்கிட்டு இருக்கு. அந்த மாதிரி தான் இந்திரா காந்தி கவர்மெண்ட் கிட்ட உனக்கு 39 பிஎன்சின்னு 2 ஆர்டிகல் சொன்னேன், பட் நீ என்டையர் டிபிஎஸ்பி எக்ஸ்டெண்ட் பண்ணிக்கிட்ட அப்படின்னு சொல்லி தான் மினர்வா மில் கேஸ்ல வந்து they would have restricted the இது அதெல்லாம் கிடையாதுன்னு, உனக்கு அடுத்த வருஷம் சம்பளமே இல்லைங்கிற மாதிரி. ஸோ ஜோக்ஸ் அப்பார்ட், so that is the first amendment which was brought in 42nd. 42nd கொண்டு வந்த ஒரு முக்கியமான விஷயம் என்னது, this extension which was scrapped. Actually 42nd amendmentல கொண்டு வந்தது almost 90% it is scrapped தான் by 44th amendment, but still we'll discuss all the amendments, controversial amendments. So one crucial amendment which 42nd amendment brought was in the preamble itself. They added 2 new words called socialist and secular, and they also added another word called integrity under fraternity. Fraternity ங்கிற சப்ஹெட்டிங்ல they added this word called integrity of the unity and integrity of the nation. So அந்த example is that is very crucial amendment which is existing till present day. So India is a secular nation and India is considered to be socialist, not in the economic per se, but India வந்து நம்ம socialist ன்னு how we can say socialist னா like yeah we opened up the economy, LPG reformலாம் வந்துருச்சு, இன்னும் சோஷியலிஸ்ட் சொல்லலாமா அப்படின்னு பார்த்தா சொல்லலாம். ஏன் சோஷியலிஸ்ட்னு சொல்லலாம்னா still we are ensuring a lot of welfare, government is implementing a lot of welfare scheme, government is running PDS. அம்மா உணவகம்லாம் என்னது, சோஷியலிஸ்ட் தானே, பிரின்சிபல்ஸ் தானே. So still we can say because providing welfare, PDS, subsidy, MSP இது எல்லாமே socialist principles தான். So அதனால வந்து providing welfare is part of socialistங்கிறதுனால we can accept the word called socialist also in the preamble. And India is of course a secular nation. கண்டிப்பா we have to triple times we can underline and say that India is a secular nation. So these amendments are present till today, and it added another important thing about which Bhaskara Krishnamurthy sir was discussing earlier, that is fundamental duties. The fundamental duties were brought. When citizens are given rights, they should also keep in mind that they are also having duties. So duties ஞாபகம் வச்சுட்டு அதையும் பண்ணுங்க அப்படிங்கிற the crucial 10 duties were brought, and of course 11th duty was added in 86th Constitutional Amendment Act with respect to education. So fundamental duties were brought in. Next வந்து made president bound. So 42nd amendmentல என்னதுன்னா, if council of ministers, நான் 42nd மட்டும் கொஞ்சம் டீடைலா சொல்றேன். If council of ministers are advising the president is bound by the advice. Bound by the adviceனா என்ன, கண்டிப்பா அட்வைஸ் கேட்டு தான் ஆகணும் அப்படிங்கிற மாதிரி சொல்றாங்க. இதை தான் 44th amendmentல என்ன பண்ணிருப்பாங்க, president can send back the advice, but if the council of ministers are sending the same advice again, then president should accept. இது வந்து qualified veto அப்படிங்கிற இந்த suspensive veto அப்படிங்கிற இந்த கான்செப்ட் வந்து கொண்டு வராங்க. not qualified veto, suspensive veto. suspensive vetoனா என்ன, பிரசிடென்ட் கிட்ட ஒரு பில் போச்சுன்னா அவர் திருப்பி அனுப்பலாம், திருப்பி வந்து சேம் பில் அனுப்புனாங்கன்னா then they should accept. So அந்த மாதிரி வந்து they are sending this even for the advice for council of ministers. So council of ministers திருப்பி அதே அட்வைஸ் கொடுக்கலாமே அப்படின்னு you can think, but council of ministers if president is sending back a recommendation, then that will create a nationwide news, and that will act as a deterrent for the government to not to give the same advice to the president again. So that is one thing, but it was first வந்து president is bound அப்படின்ட்டாங்க. no in 44th amendment they changed that into suspensive veto. That is president can send back and reconsideration and then second advice அப்போ தான் they have to accept. ஸோ அதே மாதிரி வந்து ட்ரிபியூனல்ஸ், அட்மினிஸ்ட்ரேட்டிவ் ட்ரிபியூனல்ஸ், பார்ட் 14 ஆஃப் தி கான்ஸ்டியூஷன்ல அட்மினிஸ்ட்ரேட்டிவ் ட்ரிபியூனல்ஸ் were brought and which is existing till today. அட்மினிஸ்ட்ரேட்டிவ் ட்ரிபியூனல்ல கவர்மெண்ட் சர்வன்ட்ஸ் அப்பாயின்மெண்ட்ஸ்ல வந்து if there is a problem, the case will go to administrative tribunal, which is existing till today. So that is one important amendment. Again வந்து another crucial thing na, they froze the number of seats. ஏன்னா number of seats வந்து 545 in Lok Sabha. Number of seats in Lok Sabha itself is a very big politics. Or சில states are having a lot of seats. Like UP is having 70 seats, Tamil Nadu is having 39 seats. So இந்த மாதிரி வந்து ஒரு ஸ்டேட்ல number of seats அதிகமா இருக்கிறதுனால their dominance in the national politics is increasing. So one state is dominating the national politics. So these kind of issues are coming. So it is very important to fix it. ஏன்னா எல்லா ஸ்டேட்டும் started demanding increase the seat. So அதனால what they decided, we are going to fix the number of seats. Tamil Nadu 39, UP 70. There is not going to be any change, so there is not going to be any further increase. So this is fixed. So other one they are deciding in the 42nd amendment, and that they fixed it only to 2001 தான். So 2001 வரைக்கும் fix பண்றாங்க. அதே மாதிரி they made constitutional amendments beyond judicial review. கான்ஸ்டிடியூஷனல் அமெண்ட்மெண்ட்டே ஜுடிஷியல் ரிவ்யூ கிடையாதுன்றாங்களா. ஸோ அதுக்கு தான் ஆர்டிகல் 13ல சுப்ரீம் கோர்ட் இருக்கிறதே கான்ஸ்டிடியூஷனல் அமெண்ட்மெண்ட்டை பார்க்கறதுக்கு தான். ஸோ கான்ஸ்டிடியூஷனல் அமெண்ட்மெண்ட்ஸே பியாண்ட் ஜுடிஷியல் ரிவ்யூ அப்படின்ட்டாங்க. அதுதான் அந்த பகவதி காமெடி. 2 பேர்னு சொன்னா ஒரு ஊரே கூட்டிட்டு வந்துட்டேன்தாங்கிற அந்த ஊரே கூட்டிட்டு வந்தது தான் வந்து 42nd அமெண்ட்மெண்ட். ஸோ மேட் கான்ஸ்டிடியூஷனல் அமெண்ட்மெண்ட்ஸ் பியாண்ட் ஜுடிஷியல் ரிவ்யூ. So this is was again removed, curtail the power of judicial review. This is one important thing. அதே மாதிரி another important provision which was brought is crucial decision which was brought by 42nd na DPSP la they brought that there should be free legal aid for poor. Free legal aid na poor people they cannot afford lawyer, avங்களுக்கு free legal aid வரணும். So this was a very important provision which was ordered. Then வந்து participation of the worker in the management of industry, and then protection of environment and forest and wildlife. So environment related provisions were brought under the DPSP, and there is also one fundamental duty regarding environment, and it was brought under 42nd amendment. So it facilitated proclamation of national emergency in particular part of territory. முன்னாடி national emergency full India இல்ல, ஒரு particular territory also we can bring in the national emergency. So this was one important features. Next வந்து it shifted 5 important subjects from the concurrent list, state list to concurrent list. That is education, forest, protection of wild animals, அதுக்கப்புறமா வந்து and administration of justice. All these things were moved from concurrent list to state list to concurrent list. So this survived. இது எந்த சேஞ்ச் வரல. இன்னொரு முக்கியமான காமெடி என்னதுன்னா it did away the quorum. So now at present 10% of the members present ஆனதான் பார்லிமெண்ட் it is quorum. That is of 545 at least 55 MP வந்து அன்னைக்கு present ஆனதான் parliament session will go, because if parliament is taking a decision everyone should be present. At least some 10% also it should be present. Without quorum na government can arrest almost 500 MPs and put in jail, and remaining 40 MPs மட்டும் ruling party ல இருந்து வந்து they can pass any law. So that should not be allowed. So அதனால தான் வந்து quorum அப்படிங்கிற இந்த கான்செப்ட் இருக்கு. So because எமர்ஜென்சில that was only happening, all the opposition MPs were in jail. So quorum வந்து கிடையாது அப்படிங்கிற மாதிரி கொண்டு வந்தாங்க. So அப்படி பண்ணி தான் வந்து they brought in a lot of laws without any quorum. So this was also scrapped. So அதே மாதிரி all India judicial service was brought, which is still now it is continuing. So that is very important important amendment which was brought. So this is the 42nd amendment. 42nd amendment brought in a lot of provisions which was scrapped by 43rd and 44th amendment, and there are also many crucial provisions like amendment to preamble, fundamental duties, and then administrative tribunals. அதே மாதிரி வந்து DPSP ல ஒரு 4 provisions, and all these things, all India judicial service வந்து it enabled the creation but never it was created. So இதெல்லாம் வந்து very crucial part of the 42nd amendment which is surviving till today. So next, after emergency, the new government came, Janata government came, and they brought in 43rd and 44th amendment to reverse the draconian changes made by the 42nd amendment. So those draconian changes now, like 42nd amendment, there was not many important provisions. Like 43rd amendment, or important provision, it restored the power of judicial review to the Supreme Court. Supreme Court judicial review power it restored, and that is one important thing. But 44th amendment is considered to be a amendment to the mini constitution. So விஜய் வந்து வடிவேலுக்கு வந்து சம்பளமே கிடையாதுன்னு சொன்னதுதான் வந்து 44th amendment. உனக்கு இனிமேல் வந்தது எல்லாமே போயிடுச்சு. So it restored the Lok Sabha term was increased to 6 years and 7 years. So that was made again 5 years. Next one, the quorum provision, it was brought again. Quorum is very important. It was brought again. அதே மாதிரி வந்து parliamentary privilegesல we had this word called all the privileges which were provided to British Parliament, MPs of the British Parliament is also there for the பார்லிமெண்ட் ப்ரிவிலேஜை பத்தி டிஃபைன் பண்றப்போ ஒரு சோம்பேறித்தனமான ஒரு லைன் தே ரோட் என்னதுன்னா பிரிட்டிஷ் பார்லிமெண்ட் எம்பிஸ்க்கு என்னென்னலாம் ப்ரிவிலேஜ் இருக்கு அதெல்லாம் இந்தியா பார்லிமெண்ட்டுக்கு இருக்கு அப்படிங்கிற மாதிரி தே ஜஸ்ட் லைக் தட் தே யூஸ்ட் திஸ் வேர்ட். ஸோ இந்த மாதிரி வந்து இருக்கக்கூடாது. பிரிட்டிஷ் பார்லிமெண்ட்டுங்கிற அந்த ரெஃபரன்ஸ் எதுக்கு? ஸோ தே ரிமூவ் தி வேர்ல்டு கார்டு பிரிட்டிஷ் பார்லிமெண்ட் அண்ட் தட் ரிமூவ் தி ரெஃபரன்ஸ் கொலோனியல் ரெஃபரன்ஸ் இட் ரிமூவ். தட் இஸ் வெரி இம்பார்ட்டன்ட் திங். அதே மாதிரி வந்து நியூஸ் பேப்பர் கேன் பப்ளிஷ் தி ப்ரொசீடிங்ஸ் ஆஃப் தி அசம்பிளி. முன்னாடி அசம்பிளி அண்ட் பார்லிமெண்டோட ப்ரொசீடிங்ஸை நியூஸ் பேப்பர் பப்ளிஷ் பண்ணா there is a possibility for bringing in privilege notice by the legislature. So அதெல்லாம் கிடையாது, நீங்க கொண்டு வரலாம் அப்படிங்கிற மாதிரி they brought. ஸோ அதே மாதிரி வந்து இந்த சஸ்பென்சிவ் வீட்டோ அப்படிங்கிற அந்த கான்செப்ட் லைக் பிரசிடென்ட் கேன் ரீகன்சிடர் பட் ரீகன்சிடர் தி அட்வைஸ் ஆஃப் கவுன்சில் ஆஃப் மினிஸ்டர் பட் இஃப் தே ஆர் ரீஐட்ரேட்டிங் பிரசிடென்ட் ஷுட் அக்செப்ட். இந்த மாதிரி ஒரு ப்ரொவிஷனை கொண்டு வந்தாங்க. அகைன் வந்து நேஷனல் எமர்ஜென்சியோடைய ப்ரொவிஷன்ஸ் அண்ட் ஸ்டேட் பிரசிடென்ட் ரூலோடைய ப்ரொவிஷன்ஸ் நிறைய சேஞ்சஸ் பண்ணாங்க. நீங்க நேஷனல் எமர்ஜென்சி, ஸ்டேட் எமர்ஜென்சி, இஃப் யூ குட் ரீட் a lot of points were changed by 44th amendment. So the changes brought by 44th amendment to article 352 to 360 குள்ள இருக்குது எல்லாமே படிங்க. Because முன்னாடி internal disturbance was made into armed rebellion. Only internal disturbance இருந்தாலே national emergency we can bring அப்படின்றது. No, only if armed rebellion is there we have to bring. அதே மாதிரி வந்து national emergency can require declared only with the recommendation of the cabinet and it has to be approved within 1 month of bringing in by both the house of the parliament. Again இந்த மாதிரி ஒரு விஷயத்தை கொண்டு வந்தாங்க. Again Lok Sabha can revoke the national emergency whenever it wants. இந்த மாதிரி விஷயம் எல்லாம் வந்து it was changed. So study about the emergency ல பண்ண changes by 44th amendment. And another crucial landmark amendment வந்து என்னதுன்னா removing the right to property. ஏன்னா right to property, since it was considered to be fundamental right, a lot of laws were sent to judicial review and contested because fundamental right was breached. So இனிமேல் உங்களுக்கு fundamental right கிடையாது போங்க அப்படின்னு சொல்லி the right to property was to made into 300 article 300 குள்ள போய் போட்டாங்க as a legal right. Again, so fundamental rights guaranteed under article 20 and 21 cannot be suspended during national emergency. So this is another crucial amendment. Fundamental rights will go during national emergency, but article 20 and 21 will not go. So rights of the person for detention and at the same time rights of the accused and the right to life, இது ரெண்டும் வந்து it will not go even during the national emergency. So that is very important provision which was brought by the 44th amendment. So 44th amendment made a lot of crucial changes and it also removed the right to property. So that is the crucial thing. Study 42 and 44 in detail. Okay. So after 42 and 44, actually 40th amendment la ஒரே ஒரு சின்ன விஷயம் இருக்கு. என்னன்னா 40 I missed out. 40th amendment la there would have been a provision regarding exclusive economic zone. In the United Nations Convention on Law of Sea would have been passed. So in order to implement the provisions of United Nations Convention of Law of Sea, which determined the territorial waters, contiguous waters and exclusive economic zone and high sea, and the demarcation வந்து UN Convention UNCLOS பண்ணிருப்பாங்க. So in order to give the legal validity for the UNCLOS provision, in the territorial waters and exclusive economic zone were demarcated in the constitution itself by bringing in the 40th amendment. So 40 is about exclusive economic zone and maritime zones. You remember that. Okay. So 40 also you can add in the list. 40, 42 and 43 and 44. So after 44th Amendment Act, there were many other acts again. Trivial acts வந்து நிறைய இருந்தது. And அதுக்கப்புறம் முக்கியமான ஆக்ட் வந்து 52nd Amendment Act. So 52nd Amendment Act which discussed about the anti-defection law is a crucial thing. ஏன்னா வந்து ஆயாரம் காயாரம் culture, MPs were getting money and changing. So 52nd Amendment Act is a crucial act which prosecuted the MPs. ஆனா the same anti-defection law is again weakened. No. Anti-defection law வந்து எது கொண்டு வந்தாங்கன்னா MPs were immoral. MLAs were immorally and they were accepting money from the opposition party and they were switching the party. So in the mari political representatives becoming immoral is a joke on the representative democracy. So that's why anti-defection law was brought, so that these people are not defecting. If you are defecting, then you will be punished. This anti-defection law over the period of time, So after 30 years, 35 years, now it is being almost 35 years since anti-defection law came in 52nd Amendment Act in 1985. So now anti-defection law itself is being misused, loophole. என்னதுன்னா anti-defection law நால intra-party democracy is lost and right to dissent of an MP is being lost. Genuinely, if an MP want to do the dissent, that power of the MP to dissent against its own party is being lost. So always MP should follow அப்படிங்கிற மாதிரி ஆயிடுச்சு. So this should be reversed. So this is 52nd Amendment Act regarding the anti-defection law. So 52nd is the next important amendment. ஏன்னா இந்த political immorality was checked with the anti-defection law. Anti-defection law was needed, but it has after 35 years it has created problems. So அப்படின்னு சொல்லலாம். But here we need to balance. At one side we need to curtail the defection. On the other side we need certain reforms. So after 52nd Amendment Act, the next crucial amendment is 61st. 61st Amendment Act வந்து என்ன பண்ணுதுன்னா வந்து it increased the age of the voting power was voting rights came only in 21 years. So Rajiv Gandhi government decided in 21 years when you are becoming 18 itself you can vote அப்படிங்கிற provision வந்து they brought in 61st Constitutional Amendment Act. So that is very crucial Amendment Act. ஏன்னா it widened the youth, it empowered the youth. ஏன்னா India was entering into demographic dividend. So on the demographic dividend வந்து இன்னொரு 10 yearsல வரும்போது it empowered the youth to decide the fate of their nation. So அதனால வந்து 61st Amendment Act is a crucial one. Next 65th Amendment Act was brought, which created a separate commission for National Commission for SCs and National Commission for ST. National Commission SC ST வந்து joint commission தான் create பண்ணாங்க 65th. So 65th Amendment providing the separate commission for SCs and ST in order to check whether the provision regarding the welfare of SC and ST are implemented in a proper way. So 65th Amendment is a crucial one. And next important amendment is 69. 69th Amendment is crucial because it provided the legislature to Delhi, National Capital Territory. அதாவது நம்ம capital of India, identity of India as national capital. That national capital was provided a legislature because legislature with council of minister and chief minister, so and lieutenant governor, and it provided that there can be 7 council of minister. So இந்த மாதிரி வந்து with 70 MLA seats. So, but the 69th amendmentல வந்து even though it provided the legislature, you know what is the controversy going on. Now recently வந்து government வந்து it has curtailed the power of chief minister and it has increased the power of lieutenant governor. So அதனால வந்து the 69th amendment itself is under problem now because of the recent changes to the Delhi Government Act. Study about the Delhi Government Amendment Act 2020, which removed the lot of power of chief minister. And you know the tussle between the Delhi government and the chief minister. So after that, the most crucial landmark amendment of the constitution, that is 73rd and 74th amendment. 73rd and 74th amendment of constitution are considered to be the landmark milestone in our constitutional journey because our constitution was brought with 2-tier government, that is union government and state government. இந்த மாதிரி 2-tier government தான் வந்து we brought our constitution. ஆனா this 2-tier government போய் 3-tier government மாறுது. Our federation got a progression. So 3-tier government மாத்தினது 73rd and 74th, about which Mahesh sir was discussing about Panchayati Raj. So how local self-government to the people, implementing the Gandhian principle. Gandhi always talked about the self-sufficient village economy. So on the self-sufficiency in village will come only if panchayats and municipalities are strong, only if people are having local government. So we also discussed in an editorial in the recent times about the problems in the local self-government. So 73rd and 74th Amendment Act, which provided for the provisions of panchayats and municipality, which provided for the provisions of local self-government, and it also brought schedules. What schedules? Schedule 11 and Schedule 12. Actually, 52nd Amendment Act would have brought Schedule 10 for anti-defection law. Schedule 11 was brought by 73rd and Schedule 12 by 74th. ஏன்னா இது எதுக்குன்னா like we are having Schedule 7, which provides union list, state list, concurrent list. So division of power between union and state. அதே மாதிரி Schedule 11 and Schedule 12 talks about the division of power between the state government and panchayats. What are all the powers which the panchayat should get? But அது வந்து it wasn't not mandatory. Like Schedule 7 is mandatory, but Schedule 11 and 12 was not made mandatory, and it was made a voluntary provision. So அதனால state governments are not devoluting the powers. So that is the problem there. So 73rd and 74th amendments are crucial landmark. Next வந்து this is not very important at the national. Yeah, it is important. 76th amendment. Why I have added 76th amendment as important? Because it is very important with respect to our own state of Tamil Nadu. Because our Tamil Nadu Reservation Act of 1994, which provided 69% reservation for other backward classes, and it increased the reservation for the other backward classes and increased the total reservation to 69%. In Indira Shahani case, it was fixed that it should be at 50% only. But nammaldu vandu 69 aana piragu. So this Tamil Nadu Reservation Act of 1994 was added in the 9th schedule by 76th amendment. So அதனால தான் வந்து தமிழ்நாடுல வந்து we widened the reservation. So this is a very crucial moment. ஏன்னா தமிழ்நாடு is having a larger proportion of OBC population than compared to rest of the India. ஏன்னா தமிழ்நாடு is having highest OBC population in nation. So அதனால வந்து highest amount of reservation should be there அப்படிங்கிற அந்த ஐடியால தான் வந்து we brought this 69% reservation, and that was protected from the judicial review by this 76th amendment. Next one, the 77th amendment is also considered to be crucial because it provided the reservation for SC/ST people in the promotion also. Promotion kudukumbodum SC/ST people will be provided reservation because at higher administrative levels the SC/STs are not represented. So only if you are providing reservations in the promotion, they will be easily going into the higher administrative levels. But in order to provide reservation in the promotion, you should provide the data அப்படிங்கிற மாதிரி வந்து ஒரு catch இருக்கு. And Nagaraj case of 2007 அதோட judgment இருக்கு. Next, now again there was another judgment. So study about the reservations in promotion. That is a controversial issue which is going on. But the reservation in promotion for SC/ST so that they are represented in the higher administrative levels. And the glass ceiling effect மீறி glass ceiling effect was there even for SC/STs and also for the women. ரெண்டு gender எல்லா ரெண்டு பேருக்குமே இருக்கு. So that should be brokenங்கிறதுனால தான் வந்து 77th amendment was brought to provide reservation, but now it is under a huge controversy about which you have to study. Next வந்து அதே மாதிரி வந்து 81st amendment. 81st amendmentனா if reservationல we are allocating seats for SC/ST and OBC, if at all the seats are vacant na, that seats can be added up next year as additional seat without additional seats. 50% மேல additional seat வந்து நம்ம ஆட் பண்ணனும் அப்படிங்கிற மாதிரி ஒரு provision was brought under 81st amendment. So 81st and 77 ரெண்டுமே வந்து it is related to reservation for SC/ST in promotions and vacancies. So next one, the 84th. நம்ம already பார்த்தோம்ல, like in 42nd Amendment Act, they froze the number of seats of Lok Sabha till 2001. Now in 84th Amendment Act of 2001, they froze this same number of 545 seats till 2026. So 2026 வரைக்கும் 545 seats தான். So that it is up to due for 2026 now. So 2026ல வந்து again வந்து we might increase the number of seats in Lok Sabha because 84th Amendment Act வந்து 2026 வரைக்கும் தான் சொல்லியிருக்காங்க. ஸோ அதனால தான் வந்து when we are constructing new parliament is having seats in Lok Sabha for 888 seats இருக்கு. பொதுவாக லோக்சபாக்குள்ள 545 MP தான் இருக்காங்க இப்போ பிரசண்டா. பட் we are constructing a new parliament with 888 seats, which means that there is a possibility after 2006 to increase the number of Lok Sabha seats. So that is another thing about 84th Amendment. Next crucial amendment is 86th Amendment. 86th amendment தான். 84 is also not crucial, but 86 is very crucial because it provided right to education for children between the age of 6 to 14 as a fundamental right. Right to education DPSP-ல இருந்தது. DPSP-ல இருந்த article 45-ல இருந்த right to education was brought in as fundamental right as 21A, and it was made fundamental right, which means that it should not be breached. Every child of 6 to 14 years of age must get the school education. So that is 86th Amendment Act, and then Sarva Shiksha Abhiyan was brought. And next on the direct DPSP of 45 was changed that government's role is to provide the early childhood care education. அதாவது 3ல இருந்து 6 years குள்ள இருக்கிற எஜுகேஷன் வந்து pre-KG, LKG, UKG education வந்து government should provideங்கிற மாதிரி they changed it. Again they added a fundamental duty called 51AK. 51AK வந்து it is the duty of the parent to provide education to their ward. So 86th amendment is a milestone because it provided right to education. So next crucial amendment is of course 90th amendment. So why 90th amendment is crucial na? It restricted the number of person who can become council of minister. இப்போ for political reasons வந்து கட்சியில இருக்கிற எல்லாருமே மினிஸ்டர் ஆக்கிட்டு இருக்காங்க. இஷ்டத்துக்கு மினிஸ்டர் ஆக்கிட்டே இருந்தா இப்போ வந்து 234 seats தமிழ்நாடுல இருக்கு, or 545 seats இருக்குன்னா, இப்போ ruling party is winning 300 seats, they cannot make 200 ministers. எத்தனை மினிஸ்டர் நீங்க ஆகலாம்? 15% of the strength of the assembly தான் வந்து you can make ministers. That is 75 ministers தான் you can make. You cannot make more than 75 to 80 ministers. அதே மாதிரி வந்து அந்த 15% upper limit was fixed. இல்லைனா வந்து for political reason they created a lot of ministries and they political coalition pressureனால they எல்லாருக்கும் மந்திரி பதவி கொடுத்துட்டு இருந்தாங்க. So that should be curtailed in 90th amendment in 2003 was brought. Again வந்து another important thing by 90th amendment என்னதுன்னா, if a person is defecting, அதாவது if a person is defecting, anti-defection lawல if a person is disqualified, that person cannot be appointed as the minister. இமீடியட்டா வந்து அவர் வந்து மினிஸ்டர் அப்பாயிண்ட் பண்ண முடியாது டில் தி நெக்ஸ்ட் எலெக்ஷன். இப்போ பர்டிகுலர் எம்பி ஆர் எம்எல்ஏ வந்து ஆன்டி டிஃபெக்ஷன் லால டிஸ்குவாலிஃபை ஆயிட்டார். ஸோ தட் பர்சன் கேனாட் பி அப்பாயிண்டட். ஏன்னா வித்தவுட் அப்பாயின்மெண்ட் அஸ் பிகாஸ் வித்தவுட் பீங் எலெக்டட் டு லோக்சபா இட் செல்ஃப் யூ கேன் பிகம் மினிஸ்டர் ஃபார் 6 months. That is also curtailed. If you are disqualified under anti-defection law, you cannot become minister immediately. Till next election, you cannot become minister. So that crucial provision was added. Again, it ensured the parliamentary democracy. 90th amendment is a crucial one. Then came 91st. 91st amendment is a crucial one, which provided 15% upper limit, and it also brought this thing. Next, we are having next crucial amendment வந்து, of course, 97th amendment. In the 97th amendment வந்து, it provided the cooperatives. It added the right to form cooperatives under 19. DPSP ல வந்து cooperatives should be functioning. அதாவது voluntary formation, democratic control, professional management of cooperative society அப்படின்னு we added a DPSP, and we also added a word called cooperatives under article 243 ZH and ZT. So cooperative society form பண்ணது is a very important thing, because cooperative model is providing the rural rejuvenation and rural revolution. Cooperatives and self-help groups linkages are creating a lot of welfare to the rural population, and we all know the success model of Amul and Avin, how successfully they are going, and white revolution. So அதுக்காக தான். So now government created a ministry of cooperative also recently. So that is one important thing. Sundar, the doubt session வந்து we are planning to have after 9 PM. 9 PM க்கு அப்புறமா வந்து we'll have doubt session, okay? 99th constitutional amendment. So next வந்து latest amendment quick போயிடலாம், because we are having a very less time now. So next came 99th amendment act, which provided judicial appointments. There is a very big controversy. Who should appoint a judge, whether it should be collegium, which consists only of judge, whether judges should appoint them judges, or we need a commission like NJSC, like Monetary Policy Committee mari, we need whether a National Judicial Appointments Commission with the representatives of both executive, legislature and judiciary, they should appoint angiradhu dhaan. So NJSC was created with the representative of legislature, executive and judiciary, but that NJSC act, entire 99th amendment was scrapped by the Supreme Court, stating that judicial independence is a basic structure of the constitution. So 99th amendment was a landmark one, because it brought NJSC. We need NJSC, ஆனா வந்து that was scrapped, and of course let us see, at least we need reforms in the collegium system. Next, 100th amendment act is also crucial, because it solved the border dispute between India and Bangladesh. India-Bangladesh நடுவுல the border dispute was solved only in the 100th amendment. So that is a very crucial landmark moment in the foreign policy. So that is 100th amendment. So then came 101st amendment. So 101st amendment is a remarkable amendment, again we know, because it dealt 101st amendment was dealing with the GST. GST is considered to be a landmark economic reform, because GST as an idea is very crucial for India. But of course, we are having problems in GST only with respect to implementation. GST as an idea is not having any problem. GST in implementation only we are having problems, which needs to be addressed. But making one nation, one tax is very important to create one national market. Of course, state law, the taxation powers and compensation issues, which needs correction. So GST and 101st constitution is a landmark amendment, because we had a midnight parliamentary session we had during the launch of during the India's independence. And the mari or midnight 12 o'clock session la prime minister and president together they launched the GST. So it is very important milestone. Next, in 102nd, constitutional status was given to National Commission for other backward classes. So that is considered to be a very important amendment. National Commission of OBC were given the constitutional status. 103rd amendment is an again important amendment, because it provided reservation, 10% reservation for economically weaker section. So providing reservation to economically weaker section is under judicial review now. So the judgment is awaited. So we cannot discuss further on that topic, but still, providing reservation for economically weaker sections in the unreserved community was provided under 103rd Amendment Act. So next is 104th constitutional amendment, which extended the reservation for SCs and STs, but it removed the reservation given to Anglo-Indian community in the Lok Sabha and in the state legislative assembly. So in Lok Sabha 2 seats and in state legislative assembly 1 seat is reserved for Anglo-Indian community, but that provision of reservation was removed after 104th constitutional amendment. And 105th constitutional amendment is about clarification. So it said that states also can determine the list of other backward classes. So which all the following castes are coming under OBC? And the identification of caste power is also given to the state government. Now state government also can identify which all castes are coming under OBC. So this is the latest 105th amendment. That is the latest amendment which was brought. So these are all the crucial amendments, guys. These amendments are the landmark one. I'll just re-say the numbers. Number 1, 7, 15, 24, 25, 33, 42, 43, 44, 52, 61, 65, 69, 73, 74, 77, then 81, 86, then 97, and from 99 onwards, study everything. So in the amendment brief for answer writing purposes, you can quote in the answers also. So remember all these numbers. If you want to know the numbers again, replay panni paranga, you will get the numbers. So at the end of the session, I would like to talk about amendments which are needed in the constitution. So constitution needs a lot of amendments more. Idukapparama amendment thevayana at this juncture. What are all the amendments needed now? After 72 years, we also need a lot of amendments. Like we need certain amendments with respect to President rule as proposed by Bommai case judgment regarding the rights when the President rule can be implemented. Again, Sarkaria Commission also and Punchi Commission also gave recommendation with respect to President rule which should be implemented. President rule implement பண்றப்போ whether the state legislature can be dissolved or whether the council of minister can be resolved. இத பத்தி தான் we have to know. 90th amendment is also crucial about which I said. So this is what was discussed in the president rule. Next powers of the governor. Powers of the governor again there is a lot of changes which is needed in the power of the governor. Next powers of the governor governor should be a politically neutral person. He should be outside the state. Adhe mari governor should be appointed after the consultation with the chief minister. Adhe mari governor should have 5 years term. It should not be removed. Governor should take a decision immediately with regarding the referring the bill to the president. Okay, governor if it is referring the bill to the president, the decision should be taken immediately. And we need to fix the upper limit. US parliament is having upper limit. President should make a decision within 14 days. 14 நாள் குள்ள decision எடுக்கணும். But we are not having any upper limit. President can pocket veto. அதே மாதிரி இந்தியால கூட we are having this pocket veto. So we need to fix this upper limit. So that is one amendment which is needed as provided in the Punchi Commission. Next National Committee for Working of the Constitution. Venkatachalaya Committee கொடுத்த recommendation, a lot thing can be considered. Again official languages, article 351 with respect to official language, that needs change, and all the 22 languages in the 7th schedule can be recognized as official language. Of the 8th schedule can be recognized as official language. Next, power of the speaker with respect to anti-defection law and money bill. We need changes because that is being misused a lot, and anti-defection law itself needs an amendment because anti-defection law la enna or provision thevana it should be applicable only for crucial decision like vote of confidence or budget passing, vote of confidence. In the mari crucial decision, no confidence motion time la dhaan it should be applicable, not for the passing of bill la. Bill passing la whip should not have power, and anti-defection law should not come into force. So this amendment is needed. And another important thing is election commission's appointment. The election commission members of the election commission should be appointed by a committee consisting of legislature, executive and judiciary, prime minister, leader of opposition, chief justice of India. Okay, இவங்க 3 பேர் இருக்கிற committee தான் should appoint, not the appointments committee of cabinet. So this is one amendment which is needed. Then a lot of fundamental rights should not be scrapped even during the emergency, like article 17, article 25, article 24, article 23 and article 32. In the article also should not be curtailed during the emergency. This is a crucial amendment. And last amendment which I am suggesting, constitution is having a lot of word called he. எங்கெங்கெல்லாம் கான்ஸ்டியூஷன்ல he இருக்கோ, it should be made he or she, or a gender neutral term should be brought. Our constitution should be politically correct. It should have gender neutral terms. So எங்கெங்கெல்லாம் he இருக்கோ, it should be he and she. So this is another amendment which I suggest personally to the Parliament of India to consider. So these are all the amendments which I am suggesting. So with this note, and இன்னொரு முக்கியமான crucial amendments என்னதுன்னா 21st amendment which brought Sindhi language, 71st amendment which brought Konkani, மணிப்பூரி, நேபாளி. அதே மாதிரி 92nd amendment which brought போடோ, டோக்ரி, மைத்தாலி, சந்தாலி. இதெல்லாம் வந்து ட்ரைபல் ரைட்ஸ் கொடுத்த amendments, recognize the languages, increase the scope of 8th schedule. So these are all the crucial amendments. So with this note, I would like to wind up my session regarding the landmark amendments in the Constitution. So thanks KingMakers IAS Academy for conducting such a marathon event. So thank you all. If you're having any doubts, join us again at 9 after 9 p.m. We might have the doubt session. So thank you.